Thank you. Again, I appreciate this opportunity. I am April Troemper. I'm the 7th Circuit Court Judge. I have been a trial court judge since 2009. I preside right now down in Macoupin County, but it is a 6-county territory, which includes Sangamon, Macoupin, Morgan, Jersey, Scott, and Greene. I have been in the current position that I'm running an election for since April 2nd, 2015. I was appointed as an associate judge in 2009 by the 12 Circuit Court judges as being the most qualified. In 2011, they retained me for another 4-year position. And then when Judge Londrigan announced his retirement in December of 2014, that created a vacancy. And because that vacancy was going to be open for almost 2 years before the election, Chief Justice Rita Garman put together a blue ribbon committee of 4 non-lawyers and 3 lawyers to represent the 7th Circuit. They reviewed all of our applications. There were 14 of us that applied. They reviewed our applications. They opened it up to public comment, so anyone in the community could write in letters if he or she chose to. And then after that, the committee interviewed all of us, and Chief Justice Rita Garman also interviewed all of the applicants. The committee was charged with the duty to recommend 3 names to the Supreme Court for consideration, and after the interview process, I was one of those that was recommended. And then Chief Justice Garman recommended me, and I was unanimously found the most qualified by the Supreme Court to fill this position. I grew up in Edinburgh. I actually was born in Great Falls, Montana, Malmstrom Air Force Base. I'm the daughter of a Vietnam veteran. And then my dad, we relocated back to Edinburgh, Illinois, while I was an infant, where he was raised. And I graduated from Edinburgh, and then I attended Lincoln Land Community College. I earned my associate's degree. And then I went to Eastern Illinois University. I received a bachelor's degree and a master's degree. And then I transferred to SIU School of Law, obtained my Juris Doctorate degree in 1998. I am the first in my entire family to go beyond high school, so I had to finance my education through a lot of loans, which I just paid off last year, partial scholarships, and I worked my entire time. My last year of law school, I worked 4 jobs. Constantly working. I don't know what to do if I'm not working. So that's basically my background and where I am today.
What would you say are the 3 or 4 characteristics that a good judge needs to have?
First and foremost is temperament. And I say that because I deal with a very hostile call. I deal with domestic violence. I previously worked in the abuse and neglect case and anything dealing with families and children. I've also handled the criminal court call as well. So temperament, I think, is extremely important, and that is just something I believe you're born with. And I think people can have a lot of degrees behind his or her name, but temperament is very important. The love for the law, the willingness to study the law. If you don't know the law, take time, take a recess, go and study the law, and always follow the law. Also, integrity and impartiality are the other characteristics that are key for a good judge.
When you say temperament, just to go a little bit deeper on that, why especially in family court would that be so important?
Anytime you're dealing with children, the emotions are so high, and lots of times, unfortunately, I hate to use the word hate, but there's a lot of anger and disrespect for one another in that courtroom, and they come in and they want to fight. And when I say they want to fight, they really want to fight, and the tempers are very high. And by way of example, just the other day, sometimes I will allow the volume to get a little loud because I tell people, if you're willing to act that way in front of a judge, and sometimes court security, I can only imagine how you're going to act outside in the 4 walls of your own house. So I sometimes will allow a little bit of disrespect to go on in court so I can see their true colors. But then I reach a point and it reaches a level that's unacceptable. So I had to tell the parties to take a deep breath, let's count to 10, neither of you say another word, and we'll start again. And if you cannot calm yourself down, then we'll take a recess. We'll come back, and if you still cannot calm yourself down, then we'll have to conclude the hearing for the day. But temperament is, because what I noticed is if I would elevate my voice to get his or her attention, it would just elevate theirs. So I would always say,
When your voice can't go much higher, right?
It can. I'm a mother. Yes, it can. And it has. And I said I've only had to take my gavel into court a couple times. And if I have to take a recess to go get my gavel, you know you've crossed the line. And there was one time I didn't have it, and I had to hit the bench so hard with my hand to get their attention, and it got their attention. But temperament is extremely important because I think you have to treat everyone with dignity and respect, no matter what problem they're going through. And people are there because they have a conflict. They're not there because they want to. Those that want to be are the weddings that I perform on Mondays or the adoptions. Everyone else, they really don't want to be there. So I think it's important that you keep everyone calm and just tell them there's going to be some light at the end of this tunnel, we hope, but we'll get there the right way.
Do you think electing judges is the best way to choose them?
Goodness. I will say that is the current state, and that's the state of our, the law in this state. I was appointed. I've been the recipient of 2 appointments now as an associate and now as a circuit court judge. And I believe in my heart that those appointments were based on my qualifications and my experience. It is uncomfortable actually running for this office now because I have spent I've been a judge almost 7 years, and I've spent the entire time trying to remain on my own island and not let there be any appearance of undue influence or impartiality or anything. So I had to pop my bubble and let the whole world get to know Judge Troemper and her family as I run for this spot. And it's the way we select our judges right now, and so I am a participant in it, and I am trying to get as much support as I possibly can. And as I stated to others, especially being in the position as a sitting judge, and there's different special interest groups out there, and do you cross that line and have your committee reach out to special interest groups or not? You know that's where they may be able to donate money to your campaign, and I just said it doesn't feel comfortable as a sitting judge to cross over those lines, but it is part of the process, and I'm participating in that process.
But just to follow up on that, in your opinion, do you think there's a better way?
I would like to say that merit selection is a great way. However, no matter what, there's still perhaps an underlying bias amongst those that are appointed to a merit-based committee. I don't know. I know Justice Garmon's committee. No one knows what their party affiliations were. It was nonpartisan and just made up of leaders in the community. And even though that being stated, I think people will still find criticism with that process.
Do you find the public knows much about what a circuit judge does?
No. I'm learning that. I am learning that. And so I started campaigning approximately a year and a half ago whenever I learned that I may have, originally 2 opponents running in a contested primary, and I said, oh goodness, most people don't know their judges unless they've appeared at a traffic court or some family dispute or personal injury, something, or a landlord-tenant dispute. They don't know their judges. So I've been working really hard to try to get my name out there to introduce myself to the community, but most people do not understand. So I've tried hard to go to different organizations that have invited me just to explain the differences between an associate and a circuit court judge and what we actually do, and then the different not branches, but the 3 different levels of the court system.
What would be the most important thing that the general public should know about a circuit court judge?
Well, it's different. I will say that I'm in the Macoupin County spot, so that job assignment is a little different than what the Sangamon County Circuit Court judges do. They handle mainly the felony call and the civil call, which are cases where the damages are in excess of $50,000. For me, down in Macoupin County, I'm blessed that Judge Londrigan, the call that he had, is the exact same call that I was handling as an associate judge, which is the family domestic relations call. So in Macoupin County, again, it is different, but I am also in charge of the drug court program, which is something I was not in charge of as an associate judge. So the level of responsibilities increase. I tell people by statute the difference is associate judges do not hear felony cases unless there is a request by by the chief judge of the circuit to the Supreme Court to allow associate judges to preside over felonies. And it happens all the time. So associates in our circuit do preside over felony cases because they've been granted permission by the Supreme Court. The other difference is that associate judges are appointed by the circuit court judges, and the circuit court judges actually run for an election. And associates are retained for a 4-year term. Circuit court judges are retained for a 6-year term. Also, there are more administrative responsibilities that come with being a circuit court judge. And theoretically, you hear more complicated and complex cases as a circuit court judge.
Could you back up and talk a bit about your legal experience before you were appointed to the bench?
I sure would.
And what you specialized in?
I sure would. Actually, even before I was a licensed attorney, I had a lot of experience clerking for the state's attorney's office and the public defender's office, the federal public defender's office, and the United States attorney's office. So I really thought my career path was going to be in the criminal arena. However, ended up starting a brand new family and took the bar exam about 7 months pregnant and passed it first time, exactly. He let me know he was present during the written part and had to keep sitting straight up. So after having a child, I was offered a job with the federal public defender's office, and it was going to be in Peoria, and we did not feel that that was in our family's best interest at that time to make that commute, having a brand new family. So I received a job offer at Graham & Graham, and that's a small firm here in Springfield, and they represented the Hospital Sisters Health System and the Catholic Diocese. And so I started my legal career in the medical malpractice arena. Primarily, and I did my very first jury trial 6 months after law school with my colleague Rick Wilderson. He knew I wanted to do litigation and jury trials, and he asked me, and I said, "Oh, I'd love to." And I said, "When is the trial?" And he said, "Next week." I said, "Next week? Oh my gosh!" And he goes, "Yes, I'd like for you to do the opening statement, and I'd like you to do the direct examination of the nurses." I said, "Okay, no problem." And so I had depositions scheduled in Florida for other doctor expert depositions. And so I took that other file and I just prepared as much as I possibly could. And it was a very long trial. The jury returned a verdict, a $7 million verdict against the hospital and the doctor. We represented the nurses in that case, and we knew that they did not have the necessary testimony for causation to legally hold the hospital liable. So we filed what's called a judgment notwithstanding the verdict, and the trial court granted that, which basically said he agreed the jury got it wrong because the plaintiff did not meet their burden of proof. And that rarely happens, where a trial court judge will set aside a verdict. It just doesn't happen. Also set aside the $7 million verdict and said it shocked the conscience and was going to set it for a new trial on damages only. Well, they appealed the case, which I can't blame them. I would appeal it too. And the appellate court affirmed, and then it went all the way up to the Supreme Court. The Supreme Court affirmed it as to our client, the nurses, but reinstated the $7 million verdict. So that case is cited in so many journal articles and by different scholars, and I've even cited it to some lawyers when they appear in front of me on a medical malpractice case. I said, "How come you've not cited this Supreme Court case?" And it just is an amazing experience that I had right off the bat. It taught a lot about myself as a brand new lawyer and what I was capable of, and I think I really earned a lot of respect by my peers in the legal community, knowing I very first trial went all the way to the Supreme Court, and we were affirmed. So I continued to do that kind of work. I also handled a class action case, some defamation, temporary restraining orders, covenants not to compete. I transferred to Ohio Royster, Velcro and Allen. Again, did a lot of personal injury work, primarily on the defense side. And then I shifted into the federal courts and handled civil rights cases where the prisoners would sue the wardens and the medical staff at various prisons throughout the state of Illinois. So I traveled and I took depositions of inmates, and I had one where the security guard had fallen asleep, and I did not let the inmate know he had fallen asleep. So anyway, and then I also handled the toxic tort asbestos litigation while I was at Ohio Royster. From there, Sorley Northrop recruited me and asked me to help them build up their litigation department. So while I was at Sorley Northrop, I was actually able to handle both sides of cases regarding personal injury, so plaintiff and defense work, and just a number of other general litigation cases. So.
Do you have any changes or projects for the courts if you're elected? Or not, you know, when you're running again here?
Right.
Yeah, you probably had a chance to see a lot and what's
I
going
have.
on and what maybe needs to be changed.
I have, and one of the things, I am very passionate about families and children. I just am. I didn't disclose this early on, but I did come from, I'll call it a broken family, where my parents divorced when I was in the 6th grade and then remarried, and they divorced again at the very end of my senior year. So I avoided family law when I was in private practice because it was too painful. And then whenever I was asked to cover this call, and I finally listened to my heart, I knew that that's what my heart told me I was supposed to do. And so I have been exposed to a lot of brokenness with these families and the lack of resources that they need to help them through some very difficult times. So one of them is we see so many self-represented litigants. They cannot afford attorneys, and they don't know how to navigate through all the rules and the pleading requirements. And if one side is represented and the other side is not, what we see is they'll come in on a motion to dismiss, and technically it's right. We have to dismiss it because they don't know the law. So the Supreme Court has created standardized forms to help self-represented litigants. Those are found on the Illinois Supreme Court website. I try to direct litigants as often as I can to that, because judges, we can't give legal advice, but we are bound to advise them as far as resources that they can go to help them navigate in this challenging legal system, and so that they don't just give up and just walk away from their case. So one of it would be funding, and I know that's not a popular topic, but funding for non-for-profit organizations. What we noticed about a year ago is some of those non-for-profit organizations were not receiving their funding at that time. And as courts, we rely on those non-for-profit organizations to provide services. For example, they have to take a 4-hour parenting class as part of any case dealing with these children, and they also have to do mediation. Well, they can't even afford mediation. They couldn't afford the parenting class, and these are the requirements that we have to tell them you have to do. So additional funding for these non-for-profit organizations to help with these parenting classes. I tell everyone, if you take these parenting classes first, then you go to mediation, we see much more success in bringing you parents together. And I said, as much as I would love to preside over your case and your children, you truthfully know what is best long-term for your child. And so trying to get them to work together early on. Also, again, the standardized forms, just more of those. It's a slow process because they have to involve everybody in the state of Illinois, and they give everyone a chance to, they open it up to public comment too, but the lawyers and the judges, we have time to comment, and trying to come up with standardized form that works for everyone is challenging, but it is needed. So in the interim, I'm trying to encourage local bar associations to work together for our own circuits to come up with standardized forms that these self-represented litigants can use. And then also limited scope representation is a way for self-represented litigants to hire attorneys on a piecemeal basis. It's called unbundling of legal services, because when they go to meet with a lawyer, they may say, I need a $3,000 retainer, and that's enough to make them walk away right then. And when I was president of the Sangamon County Bar Association last year, I created a subcommittee called Access to Justice. And the goal for that was to come up with a group of lawyers in the area willing to be hired on a limited scope representation. For example, if you're handed an interrogatory and a request to produce, most people in the public have no idea what an interrogatory and a request to produce is, and they don't answer. And then they get a motion to compel filed against them because they haven't complied. So if they could go to a lawyer and say, could you please help me with this discovery, and the lawyer be willing to just charge them for that service, that would be a big benefit as well. Or even filing an answer to a pleading or filing a motion, just limited scope representation, I think, would be a huge benefit
So are you seeing some willingness on the part of other attorneys to unbundle that?
I
or not?
have seen some more stepping up to the plate to do that. I think it's still a new area for them, but the Supreme Court created a new rule, it was about a year ago, maybe almost 2 years ago, where they're really encouraging the lawyers to do that. It was under Chief Justice Garmon's, her leadership, that she's really promoting the access to justice for those that just can't afford legal services. And I see it more in the family arena, and I see how important it is.
You mentioned you oversee drug court down in Macoupin County.
I do.
Talk about the effectiveness of that program and any ways you see that it could be improved.
Okay. The effectiveness right now, it is effective. I came in a year and a half ago, and I heard that they've had 1 or 2 successful graduates, and right now we have had 3 participants, and we just brought on a 4th participant. There has to be an agreement as to who qualifies and who's eligible to participate in it. They do relapse. They do make mistakes, and it is an incentive and a sanction type of a program. So what we're doing is we have to impose a sanction, and sometimes people immediately think, oh, put them back in jail. Well, depending upon the person, that's not the right sanction. It may be you have to go and do some community service instead, or you have to write an essay and really dig deep into your feelings and your heart as to why you're behaving this, what are your triggers. So we really can't talk case specific because it's very confidential, but it is. We have 2 that we've just promoted. Again, they're in their 3rd phase, and I'm just so optimistic and so hopeful for them, and just to see the smiles on their face and getting a job and being productive citizens. And that's the ultimate goal. Is we don't want these individuals in prison. It was their addictions that caused them to commit the nonviolent offenses to begin with. So it's fantastic. It's very rewarding to see them finally take pride in themselves and be a part of their family again. And one of them was losing his children over the drug addiction, and now he's earned the trust of the mother of his children, and just to see that relationship developing and the smile on his face when he comes to court is fantastic.
And I'm sorry, could you clarify on an earlier point, you were talking about fundraising and the challenges where you're a sitting judge. Have you self-imposed any restrictions, or?
I did. I have made it a point that I don't know who has donated to my campaign. I don't want to know. And I think sometimes people want you to know, and I understand that as well. And I'm grateful for all the contributions we have, received so far. But again, it's uncomfortable as a sitting judge to be involved in this process. I do not know who donates. I do not write the thank yous. My treasurer writes the thank yous and just keeps my campaign committee up to date on the fundraising aspect of, do I attend my fundraisers? Yes, I do. Am I aware who shows up? Yes, I am. But do I know if they dropped a check off? No, I don't know that. Some people don't. Some people just come to show support.
So on the bench, and I've asked this a couple of other candidates,
Okay.
what difference does it make, I guess, judicially, philosophically, whatever, to have an R behind your name or a D?
It truthfully does, it should not matter because we are bound to follow the law. And that's what I've told people. I take that responsibility very seriously. And I will give you an example. It was when I was an associate judge in Springfield. And I can't recall the case, but this individual made this comment because I was about ready to issue a ruling and make a comment. He said, "Do you know who I am?" I said, "Excuse me?" He goes, "Do you know who I am?" And I said, "No, I don't know who you are, nor do I want to know who you are, because it's clear you're trying to influence my decision. And I will have no part in that at all." And so philosophically, there are some areas where courts have discretion, but I can't think of too many offhand where your political viewpoints are going to come into play. If you're following the law, they should not come into play. I think it's all about your character and who you are, and just loving your job. And
Is there any final topic we did not cover that you wanted to discuss?
Let me think about that. I am a mother of 2. I mentioned Austin. My daughter would feel left out if I didn't talk about her too. So I will say campaigns, you can't do it alone. I've been very blessed to have a supportive family. And my husband, he's a teacher, a science teacher, and he's a baseball coach. So we've been coming and going in opposite directions right now, and finally finished up his junior high baseball program. But we do have a daughter, Brooklyn, and a son, Austin, who's a senior. So I'm just very blessed. And I think that also, me being a mother, dealing with these cases, I can add a personal perspective on things as well. And presiding over a murder case in Jacksonville and a wrongful death case. So I've been blessed to be promoted to circuit court judge to allow me to tap into my experiences that I had in private practice.